Welcome to all of you on Zoom to this very special Lunch and Learn. I'm Margaret Sofa McCabe, Dean of the university's law school, and I'm really thrilled today to be here with Judge Wiley Branton Jr. For this Lunch and Learn to celebrate not only Black History Month, but as a preview to Silas Hunt Day, which is coming up on the 18th. Many thanks to the Alumni Association as well as the University Admissions Office, who are our full partners in this event. Judge Branton, you may not remember this, but I do. I remember meeting you in my first semester at a judicial conference here in Arkansas, and you told us, meaning me and Tori Gaddy, my director of development, your birth story. And I was so amazed by it because I had largely really just read about the 6 pioneers on the university website and plaques around campus. And, you know, when he told me his story, 2 things happened. First, I was immediately struck by this person who I really do think was born to be a lawyer and a judge. And second, I knew if the opportunity ever presented itself to have him share not only his story, but his career with our university community, I would grab it. So I'm so excited to finally have this day come. And I also want to remind us this is something that's really striking about today. Beyond their pioneering careers, each of the 6 pioneers have families and legacies. And today we really are fortunate enough to learn from Judge Wiley Branton Jr., who's recently retired from the Arkansas bench after 27 years as a circuit judge in the 6th Judicial District, where he became known as one of the most effective juvenile judges in our state. I've read a lot about Judge Branton, and I think that the most impressive thing about this judge is his commitment to justice for all and his recognition that despite the challenges of the many cases that appeared before them, he's firmly committed to the fact that there are no throwaway people. And so today he'll share with us his experience, not only as a son of the 6th pioneer, and in particular, his dad, who I refer to as Dean Branton because he became dean at Howard University. But before we jump into hearing from him, I also want to remind us who the other pioneers were. Silas Hunt, of course, who was also a World War II veteran. George Haley, who served in the Kansas Senate and was an ambassador appointed to Gambia, West Africa by President Bill Clinton. George Howard, who became the first Black appointed to the Arkansas Supreme Court and also appointed to the federal bench by President Carter. Chris Mercer, field secretary to the NAACP, and also the person who drove the Little Rock Nine to and from school during their first semester. And last but certainly not least, Jackie Shropshire, who later moved to Gary, Indiana, where he played an influential role in that city's politics. And so when I think about those 6 people, I think about their incredible legacies. And again, it's just my honor to introduce to you Judge, now retired, Wiley Branton Jr. to share his story with us. Judge Branton?
Thank you very much, Dean McCabe. You know, one of the disadvantages of a presentation such as this is I'm not completely sure who's present and who's watching. So to be on the safe side, let me just cover all bases as I begin. So I would say to Chancellor Steinmetz, to Provost Robinson, certainly to Dean McCabe of the law school, to former Dean Nance, to retired law professor Judith Kilpatrick, should she be watching today, to the faculty and staff of the university and law school, and most important, to the students of the university who may be viewing this presentation. It is indeed my privilege to speak to you today about Silas Hunt as we begin this February month in the year of 2021, in which we also celebrate or commemorate Black history. I wanted to take particular note of retired Professor Judith Kilpatrick to recognize her scholarship on the history of African American lawyers within the state of Arkansas in general, which includes several articles she has written and the biographical book that she wrote on the life of my father titled There When We Needed Him, published by the University of Arkansas Press. My family and I remain very appreciative and grateful to Professor Kilpatrick for her scholarship in this area. I would also add that I feel fortunate today that I'm still at liberty to talk to you today about Silas Hunt and the other 5 pioneers, because the United States president who just left office seems to have been against such events as this. He did try to end efforts at diversity training within the federal government. Of course, the whole purpose of diversity training is to rid our federal workforce of various forms of ongoing bias and prejudice. This bias against correcting the historical record and accurately explaining the role that racial injustice has played in our country's development has been picked up by copycat state legislators in certain states, including Arkansas. As remains to be seen, as remains the case for so many other hot button issues in this country, I will simply say, stay tuned and we will see what transpires with respect to the general issue of what will be deemed appropriate and permissible regarding the discussion of race and bias in academic settings. As we commemorate the life of Mr. Silas Hunt, who was the first Black person to attend this university in more modern times, I want to first and very briefly talk about the other pioneers and then come back to Mr. Hunt. And of course, Dean McCabe just sort of introduced you to them. While I never knew Silas Hunt, he died a few years before I was born. I wasn't born until 51. I actually did have the privilege of knowing the other 5 pioneers. Mr. Jackie Shropshire was the second Black person to come to the law school in what I will call the modern era. Some of you all would call that ancient history. Then, of course, there's after Jackie Shropshire, there was George Haley. And of course, many of you know him as the brother of Alex Haley, the author of Roots. As Dean McCabe indicated, he eventually became an ambassador when appointed by, I believe it was President Clinton. But I came to know George Haley when he moved to the Washington area, back in around 1968. He and his wife Doris were fixtures at many of the social events attended by my mother and father. So I came to know him pretty well. Then the next came Mr. Mercer, who was originally from Pine Bluff. And of course, we know he practiced in Little Rock. Then came my dad, Wiley Branton, and he's obviously the person that I would obviously know the best. My dad was a veteran of World War II, having attained the rank of sergeant in the Army. He served in the Pacific. After graduating from law school, he became a relatively well-known civil rights attorney who started his practice from his hometown in Pine Bluff. He was the lawyer who filed the lawsuit upon behalf of the NAACP and Black plaintiffs, which led to the 1957 crisis at Central High School, the case being ultimately Cooper versus Aaron. He was eventually joined in that effort by Thurgood Marshall and a number of other lawyers associated with the NAACP Legal Defense and Education Fund. In the early 60s, my family moved to Atlanta, Georgia, where my father directed the Voter Education Project, which worked with other civil rights organizations to get Black people registered to vote all over the South. He was also noted for getting civil rights workers out of jails all across the South. In 1965, we moved to Washington, D.C., where Mr. Branton held several civil rights positions with the Justice Department. He eventually returned to private practice in Washington, D.C. He then became the dean of the Howard University School of Law in 1978, and that's when I moved back from Atlanta to D.C. To take over his practice. After serving as dean, he returned to the private practice of law. He died in 1988 at what I now know was the very young age of 65. And the last of the pioneers was Judge George Howard. Judge Howard was also from Pine Bluff. He too served in the U.S. Navy in World War II. After graduating from law school, Judge Howard practiced law in Pine Bluff until he was appointed to a position on the Arkansas Supreme Court by Governor David Pryor. That short service was then followed by appointment to the Arkansas Court of Appeals by Governor Clinton. And finally, President Jimmy Carter appointed Judge Howard to the United States District Court in 1979. When I was practicing law with John Walker, the late John Walker, I had the privilege of practicing before Judge Howard, and of course he passed away in April of 2007. Let me just also state that going back to Mr. Mercer, I knew him from probably when I was like 5 or 6 years old in Pine Bluff, but when I returned to Arkansas in 1989, I actually had the occasion to work a case where we both represented different clients. It was some church litigation down in Hot Springs, but our clients' interests were aligned, and we prevailed in that case. So I got to see him as a child, and he was around long enough for me to work with him once I became an attorney myself. If you look at the dates of attendance of the 6 pioneers in Fayetteville, of course, Silas Hunt was there by himself in, I guess it would have been the spring of 1948. He registered in February 1948 and was only there for that one semester. The other 5 pioneers sort of overlapped in times, but they were there from the fall of 1948 through, it looks like 1955, and at least on my information, Christopher Mercer was the last of the group to graduate. I think he was coming in and out of school for various reasons. All of the other pioneers had the benefit of the GI Bill, which helped them pay the tuition and living expenses so they could go more straight through school than, say, perhaps Mr. Mercer was able to. Now let me turn back to Mr. Silas Hunt. As you clicked into this presentation today, you may have seen a photograph depicting Silas Hunt registering at this law school in the presence of Pine Bluff attorney W. Harold Flowers and my father, Wiley Branton. This photograph was taken by Black photographer Jalevi Grice, who was a photographer who chronicled Black life during the course of his professional life. He did photographic work for Arkansas AM&N, the Arkansas State Press, and he had his own photography studio. Professor Robert Cochran wrote a book on Jalevi Grice, also published by the University of Arkansas Press, titled A Photographer of Note, Arkansas Artist Jalevi Grice. Mr. Grice certainly needs to be recognized and commended for his photographic work of historical significance. This book includes the photograph that I am talking about, as well as a few more photographs of Mr. Hunt. Just to look ahead, on Thursday, February 18th, several days from now, this university will be showing a documentary on the life of Mr. Silas Hunt, followed by a panel discussion. I would encourage you to watch this documentary if you have not done so already. One of the things this documentary does is to explain some of the events and players by which this university was willing to allow Mr. Silas Hunt to enroll in the law school in February of 1948. As I acknowledge people, I must recognize former Dean Robert Loeffler, who was a major player in the admission of Mr. Hunt. He is also one of the individuals for whom my father also had great praise. I want to acknowledge that to this audience as well as to the Loeffler family. In any event, getting back to the story behind that photograph, my father, Attorney Flowers, and Mr. Grice accompanied Mr. Hunt to Fayetteville when he went to enroll. The plan was for my father to seek admission into the undergraduate business school, for which he was denied. Mr. Hunt was going to seek admission to the law school, which was permitted. Lawyer Flowers accompanied both Mr. Hunt and my dad in case there was any trouble, and Mr. Grice went with them to document the event, and that's how that particular photograph came about. Let me now give you the backdrop into what it was those individuals were walking into back in February of 1948 and later, and I will start with the legal backdrop first. Our country's 1776 Declaration of Independence states in part that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. In the words of the artist formerly known as Prince, somebody lied. That's actually from one of Prince's songs. Some of you may be familiar with that. That would be one interpretation we could ascribe to those words, all men are created equal, in light of how Black people, Indians, and women in general were treated at that time and subsequent thereto. But another interpretation of what our founders meant by the use of the term, all men are created equal, is simply that within the context of their definition of all men, the term all men did not include people who did not look like them, or even that people who did not look like them were not men at all. That would be a fair interpretation as well. But in the present day, I choose to look at that complete phrase as an aspirational goal, which embraces all people of every description and is still a goal that we are working on. The founders' limited meaning of the term all men, as used in all men are created equal, was somewhat clarified by Article 1, Section 2 of the Constitution, which states that representatives and direct taxes shall be apportioned among the several states which may be included within this union according to their respective numbers, and the important language, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, indentured servants, and excluding Indians not taxed than 3/5 of all other persons. In other words, prior to the adoption of the 13th, 14th, and 15th Amendments, non-free persons, and think slaves and perhaps all Black people, were counted as only 3/5 of a person. In the 1857 infamous case of Scott versus Sanford, which was prior to the Civil War, Dred Scott, a slave, attempted to sue for his freedom in federal court. in writing the majority opinion holding that a person of African ancestry had no right to sue in federal court, Chief Justice Roger B. Taney stated as follows: "We think people of African ancestry are not citizens, and that they are not included and were not intended to be included under the word citizen in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States." With the victory of the Union over the Confederacy in 1865 at the conclusion of the American Civil War, and with the enactment of the 13th Amendment, which abolished slavery and involuntary servitude, the 14th Amendment, providing that all persons born or naturalized in the United States were both citizens of the United States and of the states wherein they resided, and were further entitled to the equal protection of the law. And just as a quick aside, there's new interest in the 14th Amendment about engaging in insurrection and not being able to hold future federal office, but that's another story for another day. And then there was the 15th Amendment guaranteeing the right of all citizens to vote. With the enactment of these various amendments, any truly righteous and just person would have thought that Black people finally had the same legal and political rights as their white counterparts. And for a brief period of post-Civil War Reconstruction, the legal status of Black people did improve. In fact, and this is something I actually just learned in preparing these remarks for today, in the early 1870s, a few Black citizens actually did attend the university for a short period of time, but that was very short-lived. By the end of the 19th century, the status of Black Americans had clearly and unequivocally slipped back to second-class citizenship or less. To close out the 19th century, the United States Supreme Court weighed in with the infamous Plessy versus Ferguson decision in 1896. Plessy established the so-called separate but equal doctrine, which became the Supreme Court sanctioned basis for legal separation of the races. Although Plessy actually dealt only with public transportation, the United States Supreme Court subsequently and specifically applied the separate but equal doctrine to the field of public education. Starting in the late 1930s, however, and spearheaded largely by the legal efforts of the National Association for the Advancement of Colored People, the NAACP Legal Defense and Education Fund, and the plaintiffs they represented, the doctrine of separate but equal began to erode. Later to be Supreme Court Justice Thurgood Marshall was a major player in this effort through his work as an attorney with the NAACP Legal Defense and Education Fund. There is a statute of Dr. Martin Luther King in Washington, D.C. There needs to be one of Justice Thurgood Marshall as well. If you look at his body of work over the years, there is so much progress that Black people have made. And really, when we say Black people, I think everybody in this country and a democracy benefits when we eliminate discrimination of every description. But so much progress was made because of the legal work of Justice Marshall. In the 1938 Supreme Court case of Missouri ex rel Gaines versus Canada, the state of Missouri had not provided a law school for Black citizens within its borders, and the court determined that the establishment of such a Black law school within the state of Missouri was a discretionary matter with state officials. Therefore, the Supreme Court held that requiring Black Missouri citizens to obtain their legal education outside the state of Missouri, even at the state's expense, nevertheless denied the equal protection of law as guaranteed by the 14th Amendment to Missouri citizens. Let me just sort of digress a little bit here. The NAACP Legal Defense and Education Fund, they understood that they weren't necessarily going to immediately dismantle the separate but equal doctrine. So they took the separate but equal doctrine and ran with it because they really knew there really was no separate and equal going on. So in the Missouri case in 38, while they won that case, and this was another thing I never picked up on until recently, that case, even though there was a winning ruling from the Supreme Court, Mr. Gaines never went to the school. He disappeared. And from the reading that I've been able to do, he was never found. So even though he got a favorable Supreme Court ruling that would have allowed him to go to the school in the state of Missouri, that case was ultimately dismissed without objection from the NAACP because Mr. Gaines could not be located. There is some speculation as to whether or not there was foul play in his disappearance. There is some indication that he felt extreme pressure being the first Black to go to that university. So as we think about what Silas Hunt did, I want you to think back to Mr. Gaines, and who got a favorable ruling, but then didn't follow through with it for whatever reason. The other thing I would point about this practice that Missouri had, that is, since they didn't have a Black law school, a Black medical school, and basically didn't have Black graduate schools available to Black citizens, what Missouri did and what Arkansas did and what some other southern states did was, rather than build a separate graduate school for Blacks, if they got pressed on the issue, they would simply pay the tuition for the Black student to go out of state somewhere else. And that indeed was practiced in Arkansas as well. Then there came Sipowell versus Board of Regents. That was a 1948 Supreme Court case wherein the state of Oklahoma also failed to provide a law school within its borders for Black citizens while providing such a facility for its white citizens. The Supreme Court held that the state must provide a law school education for a Negro applicant in conformity with the Equal Protection Clause of the 14th Amendment, and provided as soon as it does for applicants of any other group. This case had been working its way through the court system when Silas Hunt showed up at Fayetteville in February of 1948. So when Silas Hunt decided to attempt to enroll in law school at Fayetteville, the legal writing was clearly on the wall. Since the state of Arkansas did not provide a law school for its Black residents to attend, had Mr. Hunt been compelled to take legal action, he would have eventually won. My dad, on the other hand, was denied admission to the undergraduate school of this university because he could, in theory, attend a separate but equal undergraduate school at what was then known as Arkansas AM&N in Pine Bluff, the school for Negroes. And of course, my father did return to Arkansas AM&N to complete his undergraduate work before returning to Fayetteville to go to law school. That was the legal backdrop to the world into which Mr. Hunt was about to step. But I also want to talk about the general environment into which Mr. Hunt was about to step, which was also the same experience for the other pioneers. There was only a very small Black community in the Fayetteville area of the state. There certainly were no Black faculty or administrators on the campus in any capacity. There were no other Black students with Silas Hunt during his short stay there. I am going to guess that the law school faculty and top administration would have been predominantly, if not entirely, white male. As far as the 6 pioneers were concerned, the university did not provide housing to any of the Black students, and their housing options were limited on account of a custom and practice of racial discrimination and segregation. In my father's case, since he was a married man with children, he used his veterans benefits and built a house in Fayetteville where my family lived while my dad was in law school. And of course, I was born in Fayetteville while my dad was in law school. Fayetteville in those days was a very long and sometimes dangerous drive from the hometowns of the Black students, as well as the other students who came from places outside of Northwest Arkansas. This was a time before the interstate when you only had 2-lane highways. A student's only form of communication with friends and family back home was by means of letter writing. We're talking original snail mail and perhaps telephone calls if both ends were lucky enough to have a telephone, no landlines only, and maybe payphones. In an emergency, you could send a Western Union telegram if you made it to the telegraph office. The only media was newspapers and AM radio. Televisions did exist, but they were extremely expensive and not yet in regular consumer use. As for the white students at the university at that time, some of them were against the presence of Black students, many were indifferent, and some of them struck up friendships with some of the Black students. If you went to Fayetteville as a Black person back then, you were in a state of social isolation. So who was Silas Hunt, and what compelled him to seek admission to the University of Arkansas in 1948? Mr. Hunt came from very humble beginnings. He lived mostly in Southwest Arkansas, in Ashdown and the Texarkana area. He came from a single parent home, with that parent being his mother. There's apparently not much known about his father. Silas was known as a good student in the segregated schools he attended, and he went off to college at Arkansas A&M. That is where Mr. Hunt likely met my father. Mr. Hunt's studies at Arkansas A&M were interrupted by World War II. He had enlisted in the Army and served in a Black military unit. He fought in the famous Battle of the Bulge, where he was gravely wounded and left on the battlefield for dead. He was eventually discovered and treated for his wounds. He was also reportedly a member of the Red Ball Express, which was a military unit of the Army, a Black unit that drove convoys of trucks with needed supplies that supported the Allied forces as they advanced upon and pushed back Hitler's forces. In other words, he was a bona fide freedom fighter. Returning to the photograph that I have been referring to, I want to read a statement made by Mr. Grice, which is included in the book written by Professor Cochran. This is from page 41 of that book, and these are the words of Mr. Grice. He states, quote, "I knew Silas Hunt. We played football together at A&M. I think he came from Texarkana. We were both veterans. He was in terrible battles, the Battle of the Bulge. He was seriously wounded. He graduated in 1948, 2 years ahead of me. He was a junior class president in 1947. Hunt was a wonderful man, intelligent and dignified. He was in debate at Arkansas A&M. I just rode up with them and took the pictures. Harold Flowers wanted me there in case we got turned away. We all four went up in one car. Flowers drove. He had an old Frazier. I rode in the back with Hunt. Branton and Flowers were in the front. I remember the speedometer was broken. It jumped all around, said 30 miles per hour 1 minute and 80 miles per hour the next. Hunt kept looking at it, telling Flowers to slow down. Last thing we needed was getting stopped for speeding. The truth is, we were scared to death, had no idea what we were getting into. But everything went very smoothly. They treated us fine. They told Hunt he'd be admitted and turned Branton down. We had a little lunch and came on back, all except Hunt. He stayed behind. Some people in the Fayetteville Black community were helping him find housing. He wasn't really prepared to stay, didn't even have his clothes with him. Later on, when I was back in Pine Bluff, I got called in to see President Davis to know what an AM&N student was doing up in Fayetteville, taking pictures of this integration business. I told him Harold Flowers and Daisy Bates asked me to go. I guess President Davis took care of it. I never heard any more about it. The account of Mr. Grice. I next want to talk about what compelled Mr. Silas Hunt to go to law school. Let me suggest some of those reasons because I think all of the pioneers were motivated by similar reasons. First, Black people knew that they were treated as second-class citizens or worse. Every Black person, irrespective of their status in life, knew that. That was demonstrated by an unjust legal system, the routine lynching of Black people by white people, lack of equal economic opportunity, lack of job opportunities, segregation, and white and colored water fountains. By any measure and by any objective standard, it was absolutely clear that Black people did not enjoy the same rights and privileges as white people, and it was solely due to their race. Any reasonable person living under such inequality would clearly try to find a way out of such adverse circumstances. Second, Black children of that time were taught that the best way to improve your condition in life was to obtain a good education. And all of the pioneers reflect that belief and that ethic. Third, there was a certain unity that Black people had that we needed to work together to overcome this racist system. That didn't mean that all Black people thought alike or that they agreed on everything or that each person was committed to do what needed to be done, but the 6 pioneers were certainly of that view. Fourth, I think it very significant that 5 of the 6 pioneers were veterans of World War II. That very fact shows that they were committed to service. They also got leadership training and developed organizational skills while in the military. And most importantly, through their military service, they rightly believed that they earned their right to equality and equal opportunity in America. If you look at many of the early Black male civil rights activists of the 50s and 60s, you will see that many of them were veterans of World War II or the Korean War. Like many Black war veterans from both World War II and the Korean War, and after fighting for freedom overseas, they wanted freedom right here at home in the good old US of A. So now Silas is accepted into the university. He finds housing with the Black family in Fayetteville. That story is also told on the documentary. When Silas is admitted to the law school, it is done with conditions, and the big condition is that to the extent possible, he must keep himself segregated from the other students. So rather than be taught in the classroom with other students, he is taught in the basement by himself. He was eventually joined in the basement by a few other white students. I've heard variant accounts on this, and Judith Kilpatrick has written on this. I think it's covered in that documentary, but as I understand, there was a progression. It started out with Silas just being in the basement, one-on-one instruction. I think the way I remember my dad explaining it was that some of the white students thought because it was such a one-to-one ratio, they may actually get better instruction if they joined Silas in the basement. And I'm sure there are other students who did go there for more compassionate reasons, simply not to have Silas sitting in the basement by himself. At some point, the Black students, and this would have probably, and I'm not sure if this happened before Silas completed his one and only semester, but eventually, with respect to the other students, there was apparently, they allowed them into the classroom, but then they were kept in a roped off section so they wouldn't be next to their white student counterparts. And then according to what my dad told me, he said eventually Dean Leffler took the position, this isn't right, they need to be permitted to sit freely within the classrooms. So at some point during their experience at the university, the pioneers were permitted to integrate into the classroom. Still, it was a pretty tough existence. The story of Silas Hunt had a tragic and sad ending. After his one semester at the law school, he had to withdraw from the school for health reasons. He went to the Veterans Hospital in Missouri, and after a period of time, he died. It is quite possible, and I think very likely, that he died as the result of the wounds that he had received in the Battle of the Bulge. I would now like to just make a few comments about the 6 pioneers in general. They all came to this law school as mature men, with 5 of them having completed military service. They all went to the law school to get a law degree, not to make trouble. They all went to law school representing not only themselves, but representing their race, and that was a heavy burden for them to carry. I don't know that this feeling exists today. I'm kind of old school, so I carry this burden myself. But certainly in the day of the pioneers, Black people were judged by most white people by the worst of what any Black person did. So if a Black person committed a crime or whatever, according at least to the prejudiced white people, which was quite a number of them, they would view the whole race that way. And I can remember even as a child, and even in my own life experience, you read the paper and you see somebody's committed a mass murder and you say, oh Lord Jesus, I hope it's not a Black person, because they'll be messing up the race. But I kind of laugh at that now, but that was a heavy burden for them to carry, because not only were you trying to advance yourself, These pioneers were standard bearers for the race, and how they performed at the university was going to determine whether or not others would be able to follow behind them. And I don't think we can ever underestimate the heavy burdens that these pioneers carried. They were all civil but determined people. They were all gentlemen. They all made a positive difference, but each in their own way and based upon their various abilities and opportunities. And believe me, they did have to create their own opportunities. To the somewhat credit of the university, and I have to couch it in those terms, the pioneers entered the law school without a lawsuit, without a governor standing in the doorway to block their entrance, without white mob protesters, without violence, and without the need for federal troops or U.S. Marshals, which was in sharp contrast to what happened in Little Rock in '57, what happened to James Meredith when he attempted to enter the University of Mississippi. I believe that was in 1962, when Governor Ross Barnett tried to bar his entry into Ole Miss, or what happened to Miss Arthurine Lucy when she attempted to enter the University of Alabama in 1963, when Governor George Wallace tried to stand in her way. So in terms of how things could have gone, I think the university does deserve some credit for that. The lives of the 6 pioneers, as well as every other person who has contributed to the cause of equal justice, has inspired all of us who have come behind them, including me. I moved back to Arkansas in 1989 to do civil rights work with John Walker. In the early days of my practice in the late 70s, early 80s, I struck up a relationship with John Walker through my father, and it was to work on civil rights cases. I actually commuted to Arkansas in the early 80s working with John, and eventually, while I was a cooperating attorney with the Legal Defense Fund, I got hooked up with Eugene Hunt in Pine Bluff, who had a class action lawsuit against the Pine Bluff Arsenal. And I went to Pine Bluff to help him with that lawsuit. During those early years, John actually tried to encourage me to move to Arkansas, but I was a single guy at that time, enjoying life in Washington, D.C. Coming to Arkansas didn't really seem like a real attractive option to me. But eventually I got married in 1983. I soon was the father of 2 children. I left the practice to be general counsel for a government agency in D.C. But when my father died in 1988, I did a reassessment of quality of life issues. John reached out to me and made me an offer to come back to Arkansas. One of the big things was to work on the continuing desegregation case in the Little Rock School District. And of course, that involved all 3 school districts, the Pulaski, the County District, the North Little Rock School District, and the Little Rock School District. So I did come back to Arkansas in '89, and then I think I really would call myself a civil rights attorney by that point. About 4 years later, I was actually getting ready to leave the state again. For whatever reasons, I thought I needed to do that. I was trying to get a teaching job at a law school. And while I was sitting up trying to figure out what law schools I could contact, I got a call in 1993 from the governor's office. And the question was whether or not I would be interested in being a judge. So let me just give you this bit. When I got to Arkansas in 1989, there was only one circuit chancery judge. That was Joyce Warren, and she had just gotten there. But there was also a lawsuit filed. The lead plaintiff was Eugene Hunt, and you all have probably heard of the Hunt decree. But the lawsuit challenged the fact that Black people could not elect judges to represent them with the way the judicial districts were drawn up. So eventually, the lawsuit was successful, and the relief portion of the lawsuit drew a number of judicial sub-districts within existing districts, which stacked the number of Black voters so they would constitute the majority voting group in the judicial sub-districts. And as a result of the Hunt decree, we went from one Black judge among state court judges to about 15 or 17. So when I first got here, there really weren't any at all. And as the result of the Hunt decree, we then had about 15 what eventually became circuit court judges throughout, 15 to 17 judges throughout the state. Part of the Hunt decree called for the creation of a new judicial position within the 6th judicial district, that's Pulaski and Perry County. And because it was a new position, the governor had the opportunity to fill it in advance of the election that would eventually be held. So I unexpectedly became a judge. And I can tell you that I really took to that job. It's the best job I ever had. And that's really where I still look at that sort of as a civil rights job. My caseload, even though I had the authority to hear any kind of case, I was specifically assigned to preside over juvenile division cases, which consist of child abuse and neglect cases, juvenile delinquency, status offender cases. Those are, we call those family in need of services cases. We also did some custody and support cases. But the reason that I connected with that particular caseload is because I felt that I had developed a good skill set to deal with the population of litigants that were coming through the court in that way. The litigants in those cases were predominantly poor, disproportionately Black, and they were children and families in crisis. And if you're going to be an effective judge of those cases, it requires more than just knowledge of the law. Certainly, you had to know the rules of evidence, you had to know the rules of procedure, you had to know constitutional due process, but you also needed to know something about child psychology. You also had, and since the judges were charged with the responsibility of changing unacceptable behavior into acceptable behavior, you had to work with these children and families over a period of time. In many respects, I was like a social worker because that's the kind of work that you were called upon to do. But I connected with this job in a way that I did not envision. And I cannot think of a better use of my time and education than those 27 years I served as a judge presiding over juvenile division cases. Let me also add that I had sufficient seniority that I could have moved on to other caseloads, adult criminal cases, any kind of civil case. And certainly I had the qualification and background to do any of those cases. But I wanted to make a statement to my colleagues and really to anybody else who would listen that these juvenile division cases were and are important cases, and they demand the best of us that we have to offer to them. So that was my commitment to that group of cases. And the other thing that I would point out about the Hunt decree is this. There is the Arkansas Judicial Council, which is made up of the judges, your circuit court judges, your Court of Appeals judges, your Supreme Court judges, and it's the organization for judges to try to advocate for our needs, for our education, resources, what have you. And so in '89, you might have had one Black member. There probably would have been 120, 130 members of the Arkansas Judicial Council. As the result of the Hunt decree, you now had an influx of Black members of the Arkansas Judicial Council. And I would submit to you that that was very beneficial to the other members of the Judicial Council. For many of them, when we came in under the Hunt decree, that was probably the first time some of those judges would have had the occasion to have any social interaction with a Black person on an equal basis. And I think if you talk about improving our judicial system to make sure that there's justice for all, I think it's important that our judiciary be as diverse as our population. So I think the Hunt decree certainly has been beneficial in that regard. Since the days of the six pioneers, we have undoubtedly made a lot of progress. Let me check my time. Since the days of the six pioneers, we have undoubtedly made a lot of progress in ending various forms of discrimination. A look at the composition of this university from students to staff and administration shows the progress which has been made. When I returned to this state, there are now a number, in addition to the judges, there are now a number of Black elected officials all over the state, as well as all over this country. I had intended, and I'm getting close to my time, I didn't think I was going to go this long. I wanted to talk about the events of January 6th, because that was an assault on our democracy, and there was certainly a racial significance to some aspects of that attack. I'm not going to address that today, but I want to let you all know that in my nearly 70 years of life, we are now at a major crossroads in America. I hope the law school will see fit to discuss the significance of the events of January 6th with the storming of the Capitol with your students, and that everyone clearly understand how much our democracy came under attack that day and how close we were to losing our democracy. And I still think we're at risk. But I'm going to have to save those comments for a different occasion.
And we will look forward to hearing them when you want to share them, Judge Branton. We are just about out of time today. I can't thank you enough.
I just want to say one more thing about Silas Hunt, because it's short. As I close today, I want to focus back up on the life of Mr. Silas Hunt. His life was tragically cut short. He didn't even get to complete his studies here at the law school. But I submit to you that had he been able to continue in life's journey and knowing about the challenges he was willing to undertake in the military service of his country during World War II, and his willingness to be the first Black student at the University of Arkansas in modern times, under all of the circumstances which I have attempted to describe, leads me to the firm conviction that had he lived a much longer life, he would have lived and led a life that would have rivaled the post-law school accomplishments in a very positive way of the other 5 pioneers who followed him. We should all be thankful for the things that he did do in the time that he lived. Thank you, Dean.
Thank you, Judge Branton. That was wonderful. We'll give you a round of virtual applause. I've learned so much from you today, and I know I speak for our community when I say thank you, not only for your time, but clearly for returning to Arkansas in 1989, for being one of the judges who has brought diversity to the bench, for bringing understanding to juveniles who really need it in a way that, as you've articulated, may feel sometimes more like social work than legal work, but you know more than anyone how important that work is to their future in Arkansas and feeling like they're valued citizens. So for our listeners today, I hope that you learned a tremendous amount. There's some things that I just want to remind you about that Judge Branton shared with us. That aspirational goal of justice for all remains an aspirational goal, and one that we always have to pursue and keep in the forefront of our minds. I know for those of us on campus, terms like social isolation or feeling like a second-class citizen are not unfamiliar. And so we still have more work to do to make sure that our campus and in our individual colleges and schools, that we are welcoming to all, and that we embrace democracy and the rule of law. And for that, I just thank you, Judge Branton, for inspiring us today and sharing the legacy of a 6th pioneer. And we hope that those waves reverberate into the future too, and that we just see more positive contributions from all people to the justice system and to our communities. So thank you again for being here. I'd also like to thank our own Edison Williams, our DEI coordinator here at the law school, Lacey McKinnon of the Alumni Association, and Rafael Garcia of University Admissions for making today happen with Judge Branton. We couldn't have been more pleased to have spent the last hour with you, and we look forward to hearing your views on the 6th in the future. So thank you all for joining us, and I hope you all enjoy the rest of your day.